Hello, Jeff Hacker with Bayside Property Management and Leasing located in Sausalito, California. Today's blog is Discrimination in Residential Housing. It is often difficult to navigate the murky waters of residential property management in respect to discrimination. Oftentimes a prospective tenant will ask a question that if you were to answer it in the same way can leave you open to charges of discrimination. For example, a prospective tenant may ask, "Do you take children?" They may be asking because they have kids and want to know if the unit that they are interested in is suitable for children, or they may be hoping to avoid kids. In either case, you cannot concern yourself with either perspective. Adult housing in California has been against the law for more than 30 years. However, senior housing, which is 55 years and older, is a bona fide niche and allowed. A variant of that question that you may get asked is, are there many children living here? They may be hoping for a positive response, or alternatively, a resounding no. In either case, an appropriate response to questions like that would be something along the lines of, we are an equal housing opportunity provider, and people of all ages are welcome here. You can point out specific amenities that are geared for children, such as playgrounds or wading pools. If the prospective tenant pushes back, you can and should remind them fair housing laws, both state and federal, prohibit landlords from collecting that information and discussing it. Another question that you cannot answer, regardless of the motivation, is what kind of people live here? They may want to know if artists or musicians live here, or they may have a particular prejudice and don't want to live in a mixed community, whatever that mix may be. This is the type of question that is a prohibited topic of discussion as it relates to the racial, religious, or ethnic identity of tenants. You may also be asked to show a unit that is next to a family with kids, a particular racial background or religious affiliation or adults, or a unit that is not so situated. Again, you're in the hot seat here, as the applicant is doing what is known as steering to try to get you to reveal information about tenants that you are prohibited from discussing. Even if they ask if the property is in a safe or high crime drug area, you cannot answer questions like that directly, as there are pitfalls associated with questions like that. Although answering the question does not violate fair housing laws per se, it is a potentially hazardous area of conversation. If something criminal or dangerous happens to them or to the property, you can be sued for guaranteeing a condition over which you have no direct control. Or if you make a lot of negative comments about problems about the property and or neighborhood, you could be accused of trying to discourage them from applying for the vacancy. However, there are some caveats to this. If there has been recent criminal activity on the property, you should disclose it to protect yourself from potential liability. And two, in California in particular, you would be in compliance with the law if you disclosed a death that has occurred on the property within the last 3 years. As you can see from this small sample of situations, it is necessary to be well versed about discrimination in residential housing. If you have any questions regarding this, please contact Bayside Management. Thank you for watching and have a great day.